Hello, everyone. I am Kate Apostolova, and I'm a senior associate with Freshfields and a member of the YSIAC committee. On behalf of YSIAC, I'd like to welcome you to today's webinar on gender diversity in arbitral appointments and proceedings. It's very nice to see names of friends and colleagues, and we appreciate that you have taken the time to tune in, and we do hope you enjoyed this webinar. So today we will be discussing the importance of gender diversity in international arbitration and celebrate that gender diversity is increasing as reflected in the 2020 report on the progress of women in international arbitration, which was published by the International Council for Commercial Arbitration, or ICCA. As the ICCA report notes, the number of female arbitrators appointed has doubled in the past 4 years, which of course is an improvement. So today, building on the ICCA report, we will highlight the progress that has been made, and we will try to create a vision of how to move forward since there is much still to be done. We are very excited to have an all-star cast of speakers for this discussion, starting with our moderator, Professor Stacey Strong. Professor Strong teaches law at the University of Sydney, and she specializes in public and private international law. She's a prolific writer, so no doubt that those online who practice international arbitration have read at least one of her over 100 books or articles, or read a case or an arbitral award that cites to her work. Professor Strong herself also sits as an arbitrator and a mediator in national and international disputes. And importantly, for purposes of this webinar, Professor Strong was a member of the task force which drafted the 2020 ICCA report on gender diversity. So Professor Strong, thank you for joining us today, and the floor is yours.
Thank you very much, Kate. I think now in this COVID era, we're going to have to change our phrase, the floor is yours, to maybe the airways are yours. Let's kind of see if we can make that a new thing. So thank you so much for inviting me to be here and for allowing me to act as moderator of this particular function. The logistics instructions are ones that you are all familiar with. If you are not speaking, please put yourself on mute. I also will try to do that. Also, if you would like to submit a question to the panel or to any particular person, please use the Q&A function down at the bottom, along the bottom of the Zoom screen. I don't know how many of you have used that function before, but that's how we're going to be collecting questions. The chat function is turned off for our participants. So Q&A is the way to go. I'm going to move rapidly into the introduction so that we can maximize the time for our actual substantive discussion. So we have 4 fantastic speakers today. I'll run through all of the introductions because our discussion is going to be kind of weaving in and out. So first, we're going to have Sylvia Nouri, who was also on the ICCA task force, give the practitioner's perspective on the issues that we're dealing with today. Sylvia is head of Freshfields London International Arbitration Group and has previously practiced in both Paris and New York. She specializes in commercial and investment treaty arbitrations in emerging markets, including Africa, India, and Latin America. Sylvia has held leadership positions in a variety of arbitral institutions and organizations and is currently on the governing board of ICCA, where she sits on the Diversity and Inclusion Committee, the board of the SEC's Arbitration Institute, the advisory board of the ITA, and the advisory council of Africa Arbitration. She's founder and co-chair of the Global Steering Committee of the Equal Representation Arbitration Pledge, and in 2019 was included in the HEROES, beautifully spelled with capital H-E-R, and then the rest of the letters in lowercase, the HEROES Global Top 100 Women Executives list. Christine Artero is going to give the arbitrator's perspective on this, on the topics we're discussing. She's an independent arbitrator with the arbitration chambers and Fountain Court chambers. She's educated in both the civil law and the common law traditions and is admitted in Paris as well as in England and Wales. Christine has served as a sole arbitrator, a co-arbitrator, and a presiding arbitrator in matters under the rules of all major arbitral institutions. Prior to becoming a full-time arbitrator, Christine worked in private practice at Sherman & Sterling as counsel in an arbitral institution, specifically the LCIA, and as a tribunal secretary. Our third participant is Lim Seok Wee, which I hope that I pronounced correctly, who we will all know, of course, as Chief Executive Officer of YSIAC. Seok Wee is responsible for the overall management and operations of YSIAC. And before joining YSIAC, she worked in both Hong Kong and Singapore as a corporate securities and mergers and acquisitions lawyer with a number of international firms. She's also held various general counsel roles in multinational corporations before coming to YSIAC. She's qualified as a barrister and is also admitted as a solicitor in Singapore, Hong Kong, and England and Wales. We're going to have the entire world covered by the time we finish with these introductions with everybody's multiple qualifications. Last but not least, Aviva Will is another ICCA task force member who will be joining us, and she's going to be coming at the issue from the third-party funders side. Aviva is co-chief operating officer with overall responsibility for Burford's global marketing, origination, and underwriting activities. We, of course, all are familiar with Burford. And while she is in her position there, she has developed and launched the Equity Project, a groundbreaking initiative designed to help close the gender gap in law by providing economic incentives for change through a $50 million pool in capital earmarked for financing commercial litigation matters led by women. Prior to joining Burford in 2010, Aviva was a senior litigation manager and assistant general counsel at Time Warner Inc., where she managed a portfolio of significant antitrust, intellectual property, and complex commercial litigation. So as you can see, we have a fantastic panel with experience in a variety of different jurisdictions, as well as different roles within the arbitration world. So we're going to start off with kind of the baseline question, which is why diversity in arbitral appointments and proceedings is important. So I'm going to direct this question to Sylvia. Why does diversity matter?
Thank you, Stacey. So I'm giving the practitioner's aspect of this, but I guess I can give the ICCA task force report perspective on this too. And I'd say there are three key reasons really why diversity, gender diversity, matters in the practice of arbitration. The first one for me is the most important, and it's the reason why I founded the ERA Pledge about 5 years ago, and that is really talent. All talent, particularly and including female talent, has to be identified and tapped for us all to succeed, for us all to provide the best quality service we can in the world of arbitration. And the issue, of course, is if you're just tapping the male talent and promoting the best male arbitrators, you are simply ignoring 50% of the talent. And that's not in the interests of anybody, not in the interests of our clients, not in the interests of anybody who practices in the world of arbitration. And it was, I think, that understanding that to serve my clients well, I needed to put before them lists not just of male arbitrators or predominantly male arbitrators, but all the qualified candidates that were out there. That takes a little bit more work. I think part of the problem is in the past, it's easy, it's lazy, it's just so much more simple to pull off the old list that you had with the tried and tested candidates that you know will be great, that your partners have said they've seen, who are wonderful, to actually look, search, use the wonderful databases that are now provided to find other candidates who are qualified and then present a proper list to your clients. And a great example of this really is the CETA, the trade agreement between Canada and the EU, list of arbitrators. When that trade agreement was put together and a roster of arbitrators was put forward. And shockingly, while Canada did pretty well and put forward 50-50 men and women, Europe put forward a list with 20% women on it, and the chair list had not one single woman, which motivated the dynamic Catherine Simpson to go off and find a list of 70 qualified trade experts who happened to be female and put everyone to shame. I did something a little bit similar when I saw that Legal 500 had put together a power list of arbitrators in the UK, and at the bar had included only 2 women. Now there are a huge amount of talented women. You just need to look at the QCs. But beyond that, a huge amount of talented women just didn't make it onto the list. So I gave them a list of 50 that I had put together for an event to promote female barristers a little while ago, and it's not really that difficult. 2 more reasons. I don't have a huge amount of time. I don't want to encroach beyond my own, but 2 key reasons, I think. A second is legitimacy. That is not just in terms of process, but also substance, and just really the public perception of arbitration. So on the substance, I think there are plenty of studies now that show that diversity produces better outcomes. On the process, it's certainly true that the smaller the pool, the more the delays, the more issues, the more conflicts. And on legitimacy in general, well, I work in the world of ISDS, as it's now called, and there are so many question marks that have been raised about that process. A lot of them are to do with, I think, the small pool of arbitrators, double hatting, conflicts again, delays, etc., which can really be helped by broadening the pool. And that feeds into the third point that was emphasized in the ICCA report, and that is that under international law, it is a requirement to respect diversity and gender diversity. And what is nice to see in some of the new treaties that are coming out, and even BITs like the Dutch model BIT, is that we have gender diversity being underscored as a requirement under international law for all states to adhere to. So I think I'll stop there, but I can go on at more length later on if there is time.
Well, that certainly is very thought-provoking, and I have a number of questions I would love to follow up with, but you're very kind to stick to time. So you've set the groundwork for us, and now let's kind of get a better understanding of what the present situation is like. So let's turn to Christine, and can you answer the question, what are the current trends overall at the moment?
Thank you. So the current trends, I think so we can see what's been happening during the past few years, and we can see that in different ways. First, I think it's important to see what's been happening in terms of mindset, in terms of realization. I think people have, the arbitration community has really came to realize that there was an issue with diversity and that we needed to address it and how to address it and why there was this issue, you know, to find the reasons and to try to address it. So that's a major point. Then also, I think people came to realize that we're not just asking for positive discrimination and to appoint women, you know, but that the pledge and all the efforts are coming to as a mean to ensuring visibility for women who are equally competent as other men. Also, I don't know if you've noticed, but today I think when you see a list of potential candidates or you see advertisement for a panel, for a conference, and if you see only men on those lists or panel, it rings alarm bells. Now people react to this, people complain about it. So, and people wouldn't have done that, I think 10 years ago, they would just have thought it's normal. So I think, you know, the mindsets have really changed. Now, if you also look at numbers have really increased. So in the past 5 years, generally, I think the global numbers for female appointments have doubled, almost doubled, from about 12% to 21%. And that you need to remember that 10 years ago, it was only 5% of female being appointed as arbitrators. And those appointments generally, I mean, mainly come from institutions who really have to be commended for that. You can see that about a third of appointment female arbitrator appointment come from institutions. About co-arbitrator, I think I understand from the ICCA report that the numbers are not really reliable and that it's about 20%, but it's not, you can't really draw conclusions from that. And party appointment are the kind of disappointing bit, because you see that when appointments come from counsel, from parties, it drops down to 12 to 15% female arbitrators being appointed. So there is a big discrepancy if you compare the latest figure. I think if you look especially at the LCIA, last year they appointed almost 50%. It was 48% of arbitrators were female arbitrators, whereas party appointments were only 12% in LCIA cases. So I think, you know, you need to not take those changes for granted, and those have been major changes in the past 5 years. And we need to be grateful for not only the women who paved the way for us, I think in the past, organizations such as, you know, Arbitral Women and Equal Representation in Arbitration Pledge, and who have been amazing advocates of diversity. Also men, there are lots of fierce, you know, advocates, supporters of diversity, and we need to know that, to keep that in mind. And law firms, I mean, Sylvia, you will probably be able to talk about that much more than I am, but I know law firms have been taking steps also, you know, to implement new policies and to really do something about it. So now we've got about 20% female arbitrators being appointed. Is that sufficient? Probably not. I think not. And also because you have to bear in mind that those figures do not reflect repeat appointments. So those figures can actually be much lower in reality. And if you look at ICCID, in 30 years, they came from 1 female arbitrator being appointed to 48, but 50% of those female receive 85% of the appointments. So the stats can be really different in reality. What can be done to improve that? I think we still need to work on unconscious bias. If you all think who is an international arbitrator, even women will probably, most of us will think of a male, older, white probably. And I think all of us still have this unconscious bias, so we still need to work on that. And that's probably the most influential factor when it comes to appointment. I've read also about implicit bias. Is gender diversity a way of compromising on quality? You know, is it, you know, people have been saying, but we need the best candidate, then we will think about diversity. But can't you think about both at the same time? Don't you need to still consider women, you know, in the first, you know, stage of considering arbitrators? And a lack of visibility. I think I've met lots and lots of lawyers saying, we do want to appoint women, and Sylvia was mentioning that earlier, but we don't know who they are. So there has been a lot of work done on that, but still a lot needs to be done. So I think that's my view of the current situation.
Absolutely. Thank you. Thank you so much for that very insightful look and very detailed look. One of the things, obviously, you said is that arbitral institutions have been taking the lead and very successfully taking the lead in moving us forward in increasing the number of appointments. So let's move now to Siokiwi for more insight into what progress the arbitral institutions have made to date.
Thank you, Stacey. And that was a perfect pronunciation of my name, actually.
Thank you.
Arbitral institutions, SIAC was one of the earliest signatories to the ERA Pledge. I remember actually exchanging emails at the time with Sylvia and her colleagues on this. We are fully committed to gender diversity. And if you look at the ICCA report, you know, the other institutions are pretty much all doing their bit as well. If you look at SIC's numbers, in terms of female arbitrator appointments, those have gone up and gone up substantially since as recently as a few years ago. So starting from around 22% around 5 years ago, we've gone up. Last year was 36.5%. And that number is growing this year. You know, it's in the high 30% as well. And on that, we have to thank the president of the court, Gary Bourne, and our 2 vice presidents, Lucy Reed and Kavinda Bull. And we've got gender parity on the vice president. I think what has helped also, speaking from the SIC experience, is having a secretariat that's not just multinational, but is really a melting pot. It's like a United Nations of male and female lawyers from all over the world. I think that the many cultures, the many languages, and the fact that it's men and women really help when they put the lists forward internally for potential arbitrator appointments. There is the awareness there, and it really helps. And we make sure, as a matter of practice, that all our lists include at least 1 woman when we put that forward. So these are the things we are doing. I would also add that a very important part, as Christine was just saying, is that people don't know who the women are in order to appoint them. So what we try to do is to have women on our webinars, our panels, and importantly, our online training programs. Kate is very familiar with that. And the young SIC, in fact, on the committee, we have a high number of women as committee members, and we make sure, and she knows, we're always asking for new names, more women, new names, spread the opportunities. And so with the speaking slots, the visibility, particularly with webinars now on Zoom, the reach is that much further in terms of the audience profile and spread. So I think that's really helped to create more awareness, more visibility of the up and coming female practitioners to help them develop their career in future as arbitrators.
Wonderful, thank you. Certainly one of the things that I think many of us would want to think about when we get to the Q&A section at the end is this concept of putting the lists forward, which is something that the arbitral institutions have done with great success. But then the question of how do we get the people from off the short list and onto the actual appointments, because there is a little bit of a stopgap there. A lot of women are having their names put forward, but when are they going to get actually named instead of just the pride of being on the short list and not getting the appointment? So now we're going to move on to, again, a different perspective. We're going to go to Aviva and talk about how third-party funders have addressed this issue. And of course, we heard in her bio that she's working on a very interesting initiative herself. So she may talk a little bit about that as well as some other things. Aviva?
Thanks. I'll talk a little bit about sort of the what I think of as sort of the bird's eye view from where I sit. Burford is not the claimant. It's not the practitioner, and we don't make the decisions around how an arbitration gets going, whether it's the strategy or the appointments. But we do have a really interesting viewpoint from where we sit, and I want to just pick up on one of the things that's already been said. There have been huge strides in the arbitration world around promoting women. And yet we have obviously more work to do. I want to just tell you a little tiny story. I sat on a panel a couple of years ago with a number of practitioners and arbitral institution folks. And one of the gentlemen on the panel said, and I kid you not, this is in a room full of women, said, one of the reasons why women don't get appointed as much is because they don't network. They don't get out. They don't go to events in the evenings. And I sat there and I, because I'm a rather forward person, I said, they don't do that because they're watching your kids. There's still a cultural bias around promoting women. It's implicit, explicit, however you want to describe it. And there's still a culture, and we can push the culture, so far doing all the things that we're doing. And I think the arbitration world is wildly more successful at this than commercial litigation so far, at least, in the areas that we practice. So I think it's, tremendous progress. But at the end of the day, I think as long as the culture persists, and there's only so much that we can do. So one of the things that we've tried to do at Burford, and we had the privilege, I had the privilege when we started Burford, of building a culture that I wanted to work in. And I truly believe that the culture needs to shift in order for all of these initiatives to really make the difference that we want them to. So at Burford, we're very much a place that I would say is hospitable to the values and the talents that women bring to the table. And I think by and large, law firms are making the move in that direction. And certainly arbitral institutions have made huge shifts in that direction. And what Burford has done is tried to nudge them in that direction even further, using what I think speaks very, very loudly, which is dollars. So the Equity Project is as Dr. Strong said, an economic incentive to move the needle. It essentially says to law firms, we know you want to do the right thing. We're going to make it worth your dollar to do the right thing. Because let's face it, law firms are businesses. And at the end of the day, there's somebody at the top of the chain who's looking at the bottom line and saying, how do we optimize this, whatever it is, this piece of litigation, this piece of arbitration, and we have to make it worth their while to do that. So the Equity Project essentially says to law firms, if you put a woman as the first chair or in charge of a piece of arbitration or litigation, we will take the risk alongside you that particular piece of litigation or arbitration will be successful. And if it's not, we take the hit on the dollars. So we'll pay to have you promote a woman in your firm to be sort of head of that piece of arbitration. And, you know, the reaction has been really phenomenal. As the report says, 9 of the 22 champions that we've brought together, including Sylvia, to promote this are in the arbitration space. And the arbitration space has been, you know, extraordinarily strong at pushing these changes. And, you know, but at the end of the day, funding a piece of litigation is not going to change the landscape. What I think changes the landscape ultimately is when we fund a piece of litigation, the lawyer in that firm gets credit for that litigation, gets, you know, expands her reputation, ultimately gets put on the executive committee, the comp committee, all the important committees at law firms that make a difference. And then she starts helping to make those decisions at a firm. And that's what ultimately changes the culture. So the Equity Project has very lofty goals. It's not just about funding up and coming women, although that is a direct, I think, positive in the story. But ultimately, it's really about shifting the culture to a place where women are in the decision-making roles that ultimately do change a culture.
Thank you. That's terribly interesting. And again, how to help law firms do the right thing. Happily, we're going to have Sylvia touch on that exact point, what progress have practitioners made. And we've already had a question. I just want to wrap it in. She's probably going to address it already, but what kind of steps have law firms been making? So this is definitely a topic of interest, Sylvia.
Okay, well, I think there are 2 different levels to look at it from. The pledge has focused very much on the huge underrepresentation of women on arbitral tribunals. I think that was the part that shocked me. I come from a law firm where there are tons of women. Obviously, the partnership doesn't have as many women as we would like, but certainly in the associate ranks, I will say I personally never experienced any kind of discrimination. Unconscious bias, I don't know, it's unconscious. So I'm not sure how much I saw it, but I certainly never suffered from it. I always felt very, very supported. But what I did suddenly start realizing, other than the fact that there weren't enough female partners, was that I had no women on my tribunals. And so that's where I started. And I think there are 2 ways of looking at what practitioners can do. One is appoint more women to tribunals, but the other is the broader goal we've all been talking about, and that's generally promote women, make them visible. Let's support the female arbitrators of the future. So concretely, in terms of what practitioners can do to appoint more women, I agree the institutions have been phenomenal in their response and the way they are supporting women. And there's a reason for that, because of course the institutions know a lot of the female arbitrators. They've seen them in action. They know that they're good. They know where to find the qualified people. They can put lists together. They can put them forward. I've seen this at the SEC, where I'm on the board. I was also on the selection committee of the ICCA UK for several years. And, you know, again, there we made great efforts to go and find people. But the problem with arbitration, of course, is that if you are looking at it from a case-to-case basis, you are a party that has one case, you aren't really interested in the, you know, the broader, the greater good. You're interested in your one case. So it's really for the institutions and the practitioners who do this day in, day out to take a bit of a broader view. The institutions, that's their job to do it. I think they do it really well. The practitioners, they feel, oh, the pressures of the client. Well, this client won't like it, or that client won't like it. Well, the good news is that the clients do like it. And there are 2 things, as well as the dollars that Aviva has talked about, there are 2 things that really push the practitioners. That is clients, and the other is leadership. The clients are really pushing us. They're signing up to the pledge. They've got their own pledges. They've got their own initiatives. They're truly demanding it. But our leadership, I think, is really changing. And I think from my practice of more than 20 years now, the first decade, I don't think leadership was really focused on gender diversity. I'd say in the last decade, we've been talking the talk. And I think in the last 5 years, we're now beginning to walk the walk. And I'm very happy. I'm sure a lot of you have seen this, because this particular lady is currently in Singapore, but we just appointed our first ever female senior partner at Freshfields, the first Magic Circle firm ever to do so. She's a 44-year-old Australian litigator who is currently based in Singapore, and she is brilliant. And it's a wonderful testament to bringing talent through. But I think that the point there is that leadership is changing. And certainly within our arbitration practice, promoting the pledge has brought everyone really together to promote more women. I think there's been a sense of awareness among our firm that perhaps wasn't there. And it wasn't that people didn't want to promote more female candidates. It's just, as I said, when the lists are put together, you really do go with the IBM of arbitration. Well, I've sat before that person 5 times and they're brilliant. And it just takes a lot more work to go out and find people you don't know who aren't so visible, but we're not the only firm that's been doing it. And I've been delighted by seeing so many other firms rising up to the challenge at the same time. And through the work that I do on various different committees, I have to say that the response of other firms has been brilliant too. And as someone mentioned earlier, the men is what makes me really happy. Maybe it's a different generation of men whose wives aren't at home looking after the kids and whose daughters they don't want to see at home looking after the kids. And it's a leadership change that I've seen among many. So that's appointment of arbitrators. I think in terms of promoting our own people, which perhaps is what the Q&A was about, we have many initiatives from sponsorship to flexible working, mentoring. I'd say it's more a case of, again, it's leadership. It's each individual partner feeling the responsibility and accountability to promote their women as well as their men. And I think this generation of partners realizes that they need to promote whatever talent they've got. I mean, it makes no sense when you have brilliant women in your team to overlook them. You want to promote everyone who's talented. And so within my firm and others, I think you do see people individually being accountable for their women, putting more women forward. I will always, if I'm asked to speak and I can't make it, I'll always put another woman forward rather than me. When I see people in my team, and it's a stereotype, but perhaps it is true that there are some women who get their heads down, get on with the job, aren't going off looking for glory. And I just push them a little bit more towards that area. And you should have the confidence to do what others are doing because you're equally brilliant. And it just takes a little push in some cases. And that's what I think people are doing more and more, encouraging their women to be more visible, encouraging them to think that they're not asking for too much if they want to have a family and a brilliant career at the same time. So I think it's modernizing, and it's refreshing to see how many leaders are doing that. I'll just end, I think, with the part that I think has been really influential, and that's flexible working. So within my team, we have 4 women on flexible working arrangements, including myself. After going back to work after my second maternity leave with 2 children, I came back on 90%. And that 10% doesn't sound like much, but actually it empowers me once a week to pick my daughter up from school and do the thing I always wanted to do, which was stand at the school gates, pick her up, take her home, get her a snack, do her homework, and then go back to my desk. And maybe I'm at my desk till midnight, but that doesn't bother me. And that kind of thing, I think when you ask some women, why is it you don't want to stay? And they'll say, I can't imagine never picking my daughter up from school, for example, or things like that. Just a little bit of flexibility, I think, can really help promote and retain the women.
Absolutely. And, I love the stories, the different stories from different women on how they make it work. And Lucy Reed has had similar stories that I've heard from her. So thank you for that. So that's an excellent segue into kind of what's been done currently. And now let's look forward. What can be done going forward? So Sio, could you start with giving us the institutional perspective on the future?
Well, going forward, to encourage more diversity in arbitral appointments, what we have to do and what we have been trying to do is to add more women to our panel of arbitrators. And we also have a reserve panel of arbitrators that's not published, not on the website, but we do call on them and appoint people from that list, the reserve panel list, which is for people who have yet to fulfill the main panel admission criteria. So on that list, you'll find actually a large number of women and up and coming practitioners. So I think what we need to do is, as I said, to add more to both these panels and to give more speaking opportunities and opportunities to raise profiles to women generally. As I mentioned earlier, whether it's a webinar, conference, and a training opportunity at one of our academies or the university modules, is just giving them I think confidence comes in. A lot of women perhaps don't have that amount of confidence to do their very first speaking engagement or take part in a mock arbitration or anything. So I think that's what we need to do and reach out and what we do actually now is actually go beyond Singapore. So we are actually intentionally invite many women from all over the world to take part in all of these events and training initiatives.
So we have a couple minutes left on yours, and I don't want you to get away without giving all your maximum advice. And one of the questions that we had while you were speaking is for both you and Sylvia, and maybe we can get your perspective and Sylvia later if we have a bit of time. But what affirmative steps can practitioners or aspiring women arbitrators do to make themselves known to you at YSIAC, or how can they get on a roster? Do you have any suggestions?
I think people have on this panel have already spoken about networking and the importance of networking. That definitely is one at events. I find that women tend less to stay on and to network and to, you know, it's not just going for drinks. It's also maybe coming up to me, to anyone at SIAC, giving us your name card, calling on us in the pre-COVID days. But, you know, even now we're happy to hop on a Zoom meeting. So, you know, follow up my email, suggest a call, a coffee, just so that we get to know you. And to do this not as a one-off, but, you know, consistently, or actually, and the encouraging thing is many women are starting to do that, is to put your hand up and say, I would like to take part in your next event. How can I help? Can I help out on, you know, with Young SIAC? What more can I do? Can I, you know, write on the an article for the Clue Arbitration blog that Young SIAC has? There are numerous ways to do that, just so that, you know, you're on our radar and we will think of you for the next appointment.
And I like those suggestions because it really puts the power in our hands. We can go forward and volunteer ideas or volunteer our time and to work on committees. And, you know, very often people think, oh, I don't have the time to do that, but you have to affirmatively take the time. And I also like the fact that you are telling us affirmatively that you want to hear from us. You want to hear, you know, get the emails, get the indications of interest, because I think a lot of women, even those of us who are outgoing in many other ways, think, I don't want to bother. I don't want to seem pushy. And it's not pushy to simply say, I'm available. Let me make myself known to you. So that's very helpful. Thank you so much. Now let's move on, again, looking forward to the future, and talk to Aviva about third-party funders and what we can expect in the future.
Thanks. You know, as I said before, I think, you know, third-party funders don't choose arbitrators, but we do have some influence, and I think it's important that, you know, I can speak about what Burford does. I obviously don't know the inside workings of other funders, but I think it is important as you know, a party at the table, so to speak, even if we're sitting a little away from the table in terms of the decision making, to say this is important to us. This is something we care about. So in some arbitrations that we fund, a panel has already been impaneled, and the arbitrators have already been impaneled, and we have no choice and we have no influence. In other ones, you know, that's still to come in the process, and we can at least say, we'd like to see the list that you're considering. You know, we'd like to give you our recommendations. Again, client and counsel ultimately make that choice, but we can actively try to influence and at least suggest to them that it's important to us. I think that goes with taking the pledge, which obviously Burford has done, and I think some other funders as well. And it goes to being parts of conversations like this, where we continue to talk about this, continue to make it a topic of import at law firms, at, you know, and with clients, because at the end of the day, clients and law firms are making these choices, and I think we have to continue to keep them on their toes, so to speak. And you know, to the extent that we're at the table, we do try to do that. I think, you know, the other thing that, you know, COVID has obviously been an enormous disaster for the world, and something that nobody would wish on anybody. But I'm the eternal optimist, so I always look for a silver lining. And I think one of the things that we've seen is a real sort of recognition that something that Sylvia talked about, flexible working, is very possible. You know, for some amount of time in almost every country in the world, both men and women were working from home and managed to still be productive. And I think the visibility that women, you know, that women who have flexible schedules or who do some of their work at home on their own time, that visibility on behalf of, from men who now see it and see that they can also do the same thing, I think starts to level the playing field. We've seen now hearings that are remote. They may not be perfect, but we're managing. And that means that a woman who's got a young child who otherwise would not be able to first chair, you know, a hearing going on, you know, in another country, can now say, well, wait a minute, why should I not do that? I can do it remotely. And we know I can because it's been done. So I think we all have to take advantage of, you know, what is an awful situation and say, this actually changes the discussion a little bit, and it should. And I hope that one of the positives coming out of this pandemic will be that we all see and hear that this sort of flexible and we can be productive on our own time, and we can do it from home, and we can do it from wherever we are. I have to think that that's going to change the landscape going forward.
And certainly coming out of the recent election in the United States, we've already seen an outpouring of voices from young girls saying that seeing Kamala Harris as the vice president-elect has been very empowering, even to the smallest of children, 3 and 4 year olds, 7-year-olds. And so for young law students, young practitioners, seeing women on panels and seeing how they get to their career goals can be very helpful. And again, as you say, it's also educating the men of the world that women are capable. And we do have a request for war stories from people, kind of what it was like as a junior practitioner for all of our esteemed panelists. We'll hold that question for the end, but seeing how people got from A to B, although I always tell students, how I got to A to B may not be the best path for you. Every path is different. So going with that, every perspective is different. Now we're going to turn to Sylvia for the practitioner perspective on where we are going to be in a few years' time.
Thanks, Stacey. I've probably already given some of that away in what I've said already in terms of the initiatives that we've got, which are building towards the future. But I think what we're seeing now is increasing awareness. So we've broken the barrier of awareness. I think Me Too did a lot for that, not just the great work that Arbitral Women had been doing and then the pledge and what have you, but we sort of then broke through the Me Too barrier, and we're seeing a lot of awareness. And now that people are aware, it's about putting in place concrete steps that we can, as we've said, rather than just be aware and have women on lists, let's actually appoint the women. And that, that's a proxy, I think, for everything across the board. So no one likes the idea of quotas. I don't think quotas are a good idea. The pledge was expressly founded with no quotas. Targets are a different thing. I think targets are good. A lot of firms now, including our own, have targets about the number of women we want to promote to partner. It's not realistic to have targets or quotas for the partnership because, of course, people leave and all sorts of things happen. But the number of promotions, and people are, as Christine said, 20% really isn't good enough. I think 30% is a better figure to have as a target, and then maybe we can move from 30% to 40%. I'm one for incremental steps. I don't believe we should sit here right now and say it has to be 50% because we need to get the building blocks in place, and we are. So the flexible working, for example, I think has been a terrific building block, and I completely agree with Aviva that that perception has changed during the lockdown, and the way you can become visible has changed. I had a fascinating insight when I was chairing a conference which did a virtual networking chat afterwards, and I've never done a virtual networking chat, and we all got corralled into different breakout rooms, and there were sort of like 20 people in each breakout room, and it was fascinating to watch how people operated so differently virtually than they would do in person. And I think there is this sense of the big, and I'll use a sex here, but like the big man at conferences, and you lose that by being the small icon, right? There's no similar sense that there was in the past. And I think people have realized, wow, I can email people, I can pop up on people's screens, and it is about having confidence. So I think teaching our women to be more confident, showing them what this lockdown has taught us all, teaching them to be more confident and put themselves forward. I completely agree with the point about just putting your hand up. So I think as practitioners, we need to ensure that we are respecting those building blocks. The 30% targets for promotion to partnership, I think, are a great idea. And then accountability, and I'm seeing this more within firms, in our annual business plans, in our numbers within teams, people are now, leadership is asking us to be accountable. So how many women are you bringing up to partnership in your team? Are you ensuring that you're putting the right number of women on pitches, etc.? We have something at Freshfields called EDGE, which is about everyday gender discrimination. So trying to get rid of that. And it has just a list of pretty simple things you would think, but on pitches, do we have the right amount of women? Work allocation, that's critical from a firm perspective. Are we allocating the glamorous work as well as the grunt work equally. Client opportunities, who's speaking to clients? And again, I'll go back to clients being at the center of everything for practitioners. So when the clients are saying to us, you need to put more women forward on our mandates, and then that's what we're doing. So those are just a few thoughts.
Absolutely. All of those are excellent suggestions, I think, for other firms to take on. And those of us who are on the call, if you are a partner at a law firm, thinking about integrating some of these ideas into your own firm, but even if you are just a junior associate, think about taking that to your, at least when I was in practice at my firms, we would have kind of associate representatives, kind of like union representatives. And you could take these ideas to your associate rep, who would then take it to the partnership if you don't have that direct line. And the networking of what good solutions might exist. Thank you so much for that, Sylvia. Now let's go to what the arbitrators themselves can do. Christine has this fantastic perspective. Go for it. Tell us what they can do.
Well, thank you. But what arbitrators can do, I'm not sure we can do that much, but we can certainly improve the system by just, participating in that when co-arbitrators make appointment for chair, I was about to say chairman, but I can, say that female arbitrators are chairman as well. So we need to participate in that. We need to say some things if there is a list procedure going on, and if parties only propose, male for the presiding position. So we need to be part of that, obviously. But I think I'll talk also a bit about, there are quite a few questions in the Q&A about opportunities for aspiring arbitrators and younger female who wants their first appointment. We've covered quite a bit in that respect, but I think, as we've already said, don't be shy. And it is very important to work hard and to be excellent at what you do. But it won't be sufficient, and you cannot just wait for the appointment to come to you. So that they won't. Or they will take a lot longer to come. So you need to increase your visibility and to actively communicate about yourself. And it is difficult. It is difficult to self-promote yourself. It's not something a lot of people like to do, but unfortunately, not a lot of other people will do that for you. So it is important to do it in a certain way, or just, make yourself known, as we just said before. You can join committees, you can publish, you can attend and speak at conferences, or if you are not invited to speak, organize conferences for the younger generation. You can do a lot of things. In terms of network, also we've covered it, but it's difficult to combine everything. It's difficult to work and to do everything at the same time, but you absolutely need to make it one of your priorities. And in terms of my own experience, so I worked for 10 years in London. So my entire network was in London. And then when I moved to Singapore, I didn't know anybody. And before I actually decided what I wanted to do, I took 3 or 4 months to meet people. I was just calling for coffees and teas and lunches and a drink. And I met lots of people in Singapore. And then I started to work. And after I settled in Singapore, maybe after a couple of years, I thought I should do the same in Hong Kong. And so I started to go to Hong Kong 2 or 3 times a year. And I made it a point to do it 2 or 3 times a year minimum, and to meet with people. And so every time it's difficult, every time you need to get out of your comfort zone, to get out of your little group of friends, and that's when your network really expands. But after Hong Kong, I thought, wait a minute, I'm French, I should go back to Paris. So I went to the first, Paris Arbitration Week. That was a bit tough for me because I went home. And then I attended the first big ICC conference, and at the first coffee break, I thought, oh, great, I'm going to see my friends. And I walked into that huge room full of people, and I didn't know anybody, not a single friendly, known face. And I had my coffee on my own in one corner of the room. After a few days, I met people. And again, I made a point to go back every single year, and I go a few times a year to Europe, to Paris and to London, to maintain that network. And you cannot really make a name, for yourself or survive in this arbitration world without doing all these things. So it needs to be a priority. List and panels we've covered. Another virtue, if you want to get appointments, is just be patient. because you see like all those trips to Hong Kong. I mean, it's not after my first trip that I got my first appointment from Hong Kong, you know, it came after 2 years, 3 years, I don't know, of meeting with people and of knowing people. So be patient. And then when those first appointments come, you need to be able to compromise. Of course, you will get smaller cases. You need to be able to waive your traveling fees, you know, your expenses, to get on the radar of those institutions which are not in your country, you know, in your home country. And you need to do an excellent job, because that will put you, you know, one foot in, but it's very easy to get it out straight away. So you don't want your first appointment to be your last one. So obviously it's also a question of giving a good impression and doing a really good job, being available, being efficient, you know, do the best you can. So yeah, those are some advices. Yeah.
What I like about your advice and some of the advice that we've heard from some other individuals is that networking can take a lot of different forms. We often think of it as being exclusively the drinks after a conference or some other kind of event, which some of us may not be good. It may not be that we have children at home. When I was in New York, I used to have to say, oh, I'm so sorry, I have to feed my dog. So I'd have to go home and, you know, straight away and avoid the networking. But for me, it's partly because I'm an introvert, and introverts actually can network quite well in this lockdown period because we're more comfortable with just one-on-ones and small groups. One of the ways I think that is important for people to understand about these big conferences and how daunting they can be, if you can get yourself a speaking gig, the networking pressure lessens because people come and want to speak to you after not just after your individual panel, but later on throughout the rest of the conference. They'll see you, they'll come talk to you, and that is fantastic. And then the whole question is, how do you get a speaking gig? I always say, write something, because then somebody will see it and they'll invite you to be on the panel. But this is not about my advice, it's about our colleagues' advice. So come to the kind of the conclusion section, where we have an opportunity to answer some of the questions. So incorporated some of them already, but what we haven't talked about is specifically students. We talked about junior practitioners, how to get into the arbitral realm, but what tips would our panel give to young students who want to get into this field, or might be just concerned about gender discrimination issues in general? I'll let whoever wants to jump in start with that.
I'm happy to go first. Obviously, young students are the future of our law firms. Recruitment is critical. We want to make sure we're recruiting the best, and so whether that's men or women, actually we recruit more women than men. So concerns about gender diversity, I'd say certainly none. When you enter a law firm, I think the distinction comes more around promotion to partnership level, and there are lots of issues that we've discussed there that firms are working really hard on. But I'd say at the stage of being a student, it's the same advice actually at all stages. Put your hand up, be proactive, know what your strengths are and what your weaknesses are. As Stacey has said, if you're not someone who is naturally gregarious and goes around chatting to everyone at drinks parties, then find other ways that you can promote yourself. Just figure out what your strengths are and play to those. Don't be afraid, don't be shy. Don't take it as a knock. If you, I have tons of students who email me asking for a chat, and I'm afraid I can't chat to all of the students. I'll be candid about it. I can't chat to all of the students who email me, but I think, if you email 10 different people and you get to speak to 2 of them, then, fantastic. Don't take it as a knock if the busy practitioners aren't all able to. Some of them will be. But then, go out and find someone who will mentor or sponsor you. There's probably somebody that or somebody knows that will take the time to just encourage you. And then there's tons online. If you look at articles written by people as to how to break into the game, there's lots of really practical advice. And actually the ICCA report has appendices of practical advice. So read the ICCA report cover to cover and take some inspiration from there.
Thank you. Do we have maybe one other view?
I think speaking from the institutional perspective, we have many students writing to us to come and join our internship programs. And I think that really helps, because then a few of them actually have gone on to become counsel in our secretariat. And from there, perhaps a few years down the road, they move on to law firms, and they've landed really well. and gone on to make a name for themselves. And I think that path, it's an interesting one. It gives them that opportunity to sort of be known, because then when they are at the SIAC, we give lots of opportunities to our counsel in various speaking engagements, writing, etc. So that's another thought that I'd like to leave you with.
Thank you. And then I just want, we only have about 5 minutes left, but I did have a question early on in the session, and I thought it would be helpful. It was during Aviva's presentation when you were talking about the cultural stigma of not going out to drinks and doing that kind of stereotypical networking skill. Do you have any suggestions, or anybody on the panel, on how to overcome that cultural stigma, how to maybe create a new trend in your law firm about what constitutes appropriate networking?
You know, it's a really good question. I think you have to, as some number of folks have already said, you have to play to your strengths. So if what goes on in your law firm or your law school isn't the kind of networking that works for you, you have to figure out what does work for you. At the end of the day, from my perspective, you know, networking is obviously critical. Doing the work is what's going to ultimately make you comfortable in networking. So if you have opportunities, for example, if you're a junior associate and you're at a law firm, you know, ask to participate in a mock hearing, ask to be a mock arbitrator, ask to just shadow somebody who does that. But being in the room, even if you're not networking in a traditional sense, you have to be visible, and be visible in a place that makes you comfortable. So for me, that was always go to the work. But that doesn't mean go to your office, you know, behind closed doors and toil away and nobody sees you. It means do the work, but do it visibly. One of my little war stories is early on, I was preparing a partner for opening arguments at a very big trial. That morning, the partner's wife went into labor, and he did not come to the courthouse. And the partner in charge said to the client, you know, who do you want to do this? You know, I'm happy to do the opening. And the client said, well, she knows it better than anybody. Let her do it. I was a second-year associate. I promptly went to the bathroom, was sick, and then I went and did it. And I wasn't great, but I just was there. And I think that raising your hand and being visible is ultimately key to whatever networking you do. Just being in the room and being the person who's, you know, who knows the thing, whatever that thing is, whether it's the case or the relationship dynamic with the clients, just be the person who knows the dynamic.
And the recognition that your first time is probably not going to be perfect. You're not going to be Atticus Finch the first time out of the gate.
Not even the last time.
So I said again.
Yeah, I mean, I was going to say not even the last time. I mean, I've been in law for more than 25 years, and every single time I do something, I say, how could I have done it better? I'm big on the idea of a postmortem, where you look at how you could do it better, whether it's a hearing or whether it's how you handled the client or how you negotiated a deal. There's always room for improvement. Absolutely.
So we have about 2 minutes left. We got a war story from Aviva. Maybe could each of you give a 30-second war story, you know, what you learned early on in your career, or maybe the one tip that you wish somebody would have told you, or the one thing that you really want our younger generation of women to know.
I guess, well, I guess I could go first. When I was a young up-and-coming corporate lawyer, and I spent some time in Hong Kong working then, I guess one way to set myself apart then, because I was so competitive with the other male lawyers, was to really brush up on my Mandarin, because I was involved in a lot of corporate listings of companies in China at the time, and I had to travel, and everything was bilingual. And so, you know, having that language ability sort of made me somehow by default the go-to person because of the limitations of the other lawyers. So again, that applies to arbitration, because in bilingual arbitrations, and we're seeing quite a few of those at the YSIAC in Chinese and Vietnamese and other languages other than English. I think that would set you apart. And eventually, to my point earlier about when the counsel leave the institution and move on to law firms and become more senior and take on arbitral appointments, then that could be a way where they get that, that chance, that first opportunity, and then everything goes from there.
Absolutely, that development of other skills can be really, really important in advancing your career. I see we have hit time minutes. So Christine, you're off mute. Hopefully that means you're ready to jump in.
Okay, it's not a really, war story, but I remember during my first cases, don't know if it was the first or second, when I walked in the hearing room and the people preparing the hearing room and the real-time transcribers asked me when the tribunal would be coming. And it was me, but just assumed, I was just here to prepare the room or to be the tribunal secretary.
I had that happen to me on an elevator. I was going up, I was sitting as the sole arbitrator, and this senior partner fellow got in with me, and he said, "Oh, you don't look like you're from around here. Are you here for the arbitration?" I said, "Yes." And kind of laughs, and he goes, "So you the arbitrator?" And I'm like, "Yes." And he goes, "I'm not sure whether to laugh or not." And I'm thinking, laughing is not in your firm's best interest, right? Sylvia, what's your war story for us?
Oh, I'm tempted by so many different war stories I could give. Maybe back in the day, well, languages is definitely one. I totally agree. So Spanish was my language, and I went to work with a gentleman called Nigel Blackaby, who I'm sure some of you will have heard, with co-head of our arbitration team, who also speaks Spanish. And together we were in the right place at the right time when the Argentina cases came in. But I guess just that is a good enough war story. Nigel was one of those men who promotes talent, male, female, whatever they are, absolute talent promoter. And I became his bag carrier, and he pushed me at everything, which was wonderful. But I remember one of the hearings when I was doing my first ever cross-examination. It was a small one, but on the other side, it was being defended by one of the Argentine Attorney General Office's lawyers. And when I finished, as we walked out of the room together, he just shook his head at me and he said, "I pity your boyfriend." And I thought, what a typically macho way of looking at it. But I took that as a badge of honor, and I think that's the war story I would give, is that when people give you, oh goodness, sorry, I had someone trying to call me at the same time on another virtual platform. When people say things like that to you, or put you down in any way, or make you feel like a woman somehow isn't the same as a man, then you just have to laugh at it, because it's so ridiculous. So that's what I did. If ever I received comments like that, and in the world of Latin America, I had a few, I just laughed them off, and I knew that the people who knew me supported me. So be confident, know you're brilliant, know that those who care will always support and promote you, and just laugh off everything else.
And to recognize sometimes that humor amongst men, and we're in a very male-dominated area, their humor and their way of congratulating each other can sound very aggressive to us. And so something like that sounds like a put down sometimes is not, or at least I pretend to believe that. I will hand it back to Kate. She may have some logistics for us on where we can find this webinar on sources in a recorded form. Kate, do you want to finish this up? Actually, before I give it back to you, let me just say thank you so much to our panelists. If you have a little clap function, or you want to kind of indicate your happiness in some way, please do so. But I think that it's been a fantastic session. So thank you all. And Kate, any ending logistics for us?
Not really, just to let everyone know that this webinar was recorded, so it will be uploaded on YouTube. So if you want to watch it again, as you should, it will be available publicly shortly. So thank you to the panel, and thanks for all who joined us tonight. We hope you enjoyed the webinar. Goodbye.